So there's an important case decided by the Ontario Court of Appeal in 1989 dealing with a constructive dismissal. And basically what that decision said is that even if there has been a constructive dismissal, sometimes the employee may have to remain at work and accept the lesser alternative position that's been offered by the employer. For example, if there's a demotion and perhaps a modest decrease in pay, then the court may require the employee to accept that position in what is called mitigation, or the reduction of damages. Now, this decision flew in the face of every sense of logic imaginable, because to create a constructive dismissal in the first place without the issue of mitigation, there has to be a fundamental breach. That's like going to the car dealer to pick up your new car you ordered, and instead the car dealer saying, well, we don't have the 2024 Honda Civic, but we do have one that's 2 years old. Why don't you take that? Clearly, you don't have to do that. It's a fundamental breach of the contract. You don't have to take a used car to mitigate or minimize your claim, and the same thing should apply to employment law. If there's been a fundamental breach, you should not have to consider an alternative lesser position to mitigate or minimize your damage claim. Well, in any event, that's what the Court of Appeals said may be an obligation upon the employee. And after that decision was reached, it got kicked around like a garbage can through the judicial process. Madam Justice Southern in British Columbia, before she became a Supreme Court judge, Supreme Court of Canada judge, said, I find it difficult to accept that this is the law. There was a famous case in Ontario in which the judge, who was a well-seasoned employment lawyer, the late Justice Randy Eklund, said, this case, the Mifsud case, has been much maligned and seldom applied. So it looks like it's going down the garbage can pretty well. There developed a set of principles that said, well, this employee subject to a demotion does not have to accept the demotion where there's serious animosity, high-handed conduct, or the new position creates a loss of prestige, humiliation, embarrassment, a frayed relationship, etc. So it looked like Mifsud was going to be forgotten about in the annals of judicial history. However, there was a Supreme Court of Canada case that followed that I'll discuss in the next video called Evans, which gave new life into Mifsud. So I'll review that in the next video. So the point of all this is that if you're facing a constructive dismissal, get legal advice, know what you're doing, make sure you understand that there may possibly be an obligation to consider the demoted position in mitigation or reduction of your damages. This is important stuff, because if your constructive dismissal case fails, you basically ended the employment relationship and you're crossing your fingers to get a financial deal. Well, be careful, because you might not. Evans follows in the next video.